Welcome to the Essential Tax Podcast with your host, Mishkin Santa. In each episode, we'll take the complex world of tax, all the jargon, acronyms, and stuff that make your eyes glaze over, and explain it in an impactful way to understand the complex and unknown areas. You can find this show on all the major platforms, including YouTube, LinkedIn, Apple Podcasts, Spotify, and on our website, thewolfgroup.com. Now, here's the host of Essential Tax Podcast, Mishkin Santa.
Welcome to the podcast, Josh. Welcome back. You're a repeat offender.
Yeah, I prefer frequent flyer.
Frequent flyer, I love it. That's fantastic. Yes. I'm super happy to have Josh on the podcast today because this is the last. Normally, what I like to do is do kind of a kickoff for tax season. We're all, if you're a CPA or you're a tax professional and you do tax compliance work, you're probably knee deep, as we call it, the thick of it in tax returns. This is my last episode to kind of kick off tax season. We're going to do kind of where are we at here in 2025 on digital asset, cryptocurrency, compliance, consulting, things that are floating around. We get so much to talk about today. But as a quick kind of overview for everybody, at least leading up to the end of 2024, when we think about digital asset reporting, cryptocurrency reporting, and we go to kind of the extreme, the IRS, I think the last Take to report put that the IRS Criminal Investigation Division had opened about 390 cases and had done about 224 prosecutions in this space. So it's a space that they were actively working in. We'll talk about maybe where they're at today on it. I know that I saw the ex-IRS Commissioner Chuck Reddick recently talk about an experience he had where they were, talking about the use of AI to do some of these investigations and how quickly they were able to, put together information, especially in the digital asset space, to kind of, update a case file, things that would have normally taken, those folks 2 or 3 weeks of man-hour time or person time, shall we say, to put together a case file can be done in a matter of seconds now. And so there's that aspect to layering over it. But today I want to start, Josh, let's first talk about where we're at with the current regulation space. On this last podcast that we had you on, we talked about Loper Bright. We talked about the way regulations work. We talked about, the Chevron doctrine kind of being overturned. So the judicial is kind of coming in and telling the legislative branch, you're not really doing your job. You guys really got to do a better job at kind of really defining, the Internal Revenue Code. We're not going to leave it up to the IRS to just, completely tell us what to do there. But tell us where we're at with the digital asset regulations. I think, as I was mentioning before we got into the podcast today, there was a really good article in Tax Notes about the House Ways and Means Committee looking at the DeFi reporting regulations and potentially those being on the hook for being pulled. So where are we at? Give our listeners kind of a 50,000 foot view, since you're a frequent flyer, 50,000 foot view of where we're at.
Sure. So right now in the tax space, still the IRS doesn't have a whole lot to go with, right? We don't have extensive crypto legislation yet. I do think that that's something we might see actually in 2024, at least a stable coin bill, if nothing else. But once you have that legislation, it gives the IRS a little bit more to work with regulation. So their focus has still been on kind of guidance on how to treat cryptocurrency, but mostly what it's been is disclosure. And so the biggest thing that happened were the broker regs. We had those happen kind of early in 2024. And then right like in December of 2024, the IRS made good on its promise that it was going to issue something with related to the DeFi section. So, and that was, again, it's a disclosure-based thing. They were just still trying to get their hands around, everything that was out there and how it was moving and being able to do it. The other thing that happened in 2024 that is definitely important for CPAs is the 1099 DA for digital assets along those lines. And they amended that form, I think, 2 or 3 times before landing on the final one that was there, because it had a lot of information and some other things. I think that still might get amended again because, right, they haven't used it. Everybody's supposed to be keeping track of it this year and then issuing those 1099s in 2026 for 2025 transactions. But I think it still has a huge duplication problem. Most of the edits we saw to the 1099 DA were to help try and minimize this duplication problem, because right, the IRS can end up, their kryptonite has always been paper. And if you send them 6 forms for the same transaction, it just gets really messy. They have an antiquated computer system. They don't have a lot of manpower, and even less now with all the reduction in force that's going on. And they can't process that. And the problem is there's still, the way that the crypto space works, there's lots of non-taxable transactions that can occur, transfers between wallets and other things like that don't actually trigger a tax event, but would be a transaction that could still get looped in. And they've tried to carve some of that out, but the problem that I see with that is, on paper, that sounds really nice, right? Oh, well, don't do it if it's this, don't do it with that, real complicated examples and other things like that. The problem is, for a return preparer or one of these people who says, oh my gosh, am I a broker? Or, okay, I am a broker. The safest thing for you to do if you think you might be a broker is to just decide you are and comply.
Okay.
This thing for you to do, if you consider yourself a broker and you see a transaction, but you're not sure if it fits in one of these that's a duplicate, is to issue the 1099 anyway. And so, human nature being what it is, people wanting to be as careful as they can and not get in trouble, I think regardless of the explanations, you're still going to end up with a lot of duplication, which is just going to be a problem, because taxpayers, return preparers, CPAs, they're going to get 6 or 7 1099s for the same transaction that they're going to have to sort and decide which one is the actual one that needs to be reported. But in the IRS system, there's going to be 6 or 7 1099s that are probably never going to show up on anything. And then the IRS has to decide which one they think should have been reported. And if those 2 things don't match, the computer system is going to spit out a bunch of stuff that says, hey, the 1099 reported is not the 1099 we have. And I think it's going to be a gigantic mess. So I do think that we'll probably see some more amendments to that 1099 DA after the first go around results in hopefully not full bedlam, but some problems that come in that relation. Other than that, the IRS has kind of kept a tight lid on their guidance. And I think a lot of that has to do with the fact that they're not exactly sure what they can issue, and they're not exactly sure that what they do issue will stick. And I don't know if you want to get into that, but I think that's, in the crypto space, we're not seeing a whole lot. We were starting to see some, notices come out, some revenue rulings on staking. We were getting some chief counsel advice for some things, some field memos. We were seeing some informal things in crypto in 2024, but post-election, we're not seeing much of anything. The only thing substantial that we saw was the pushing through of those DeFi regs right before Trump took office. And we don't even know if it's thick.
So to summarize kind of what you're saying here, just to go back to your commentary, it sounds like what you're saying is that some people will have to make kind of a risk tolerance versus risk aversion calculus about filling out the 1099 DA. And I know that I've already gotten a lot of questions about these brokers kind of asking for what's your basis, because I think it's a really weird time where the client or the taxpayers can almost like choose their basis. Like it's like, and then once you choose it, it's there and it's like forever there. But it sounds like there's this like risk calculus about, okay, what's going to get put on that form, how you're going to do it. Then you kind of went into the fact that the IRS antiquated. I mean, I think I heard it recently. It was someone was saying, oh, some of the systems are still using COBOL from like 1968. I mean, that's that's crazy, right? But yeah, the automated underreporting system, which I think I've been concerned about for all sorts of reasons, not related to crypto, but you kind of brought that up too, and I hadn't thought about that earlier. But yeah, I mean, if you have a bunch of 1099s and then the tax return doesn't match, that system is designed to spit out and say, whoa, here's a CP 2000, you didn't report, X, then you got to deal with that. But I think where you're going to next is an issue that affects more than just crypto or digital assets. We're talking about an executive order. So let's frame it for a second.
Sure.
We're talking about an executive order issued by the president on January 31st. I'll put a link to this in the podcast. It's called Unleashing Prosperity Through Deregulation. And when President Trump was last in office, he had a very similar type of executive order that said for every 2 regulations you put out, doesn't matter which government agency you're talking about, but for every 2, you got to kill 1, right? And so the IRS dealt with that, and they worked their way through that. 2 for 1's not a really bad trade-off. But under this executive order starting Jan 31, and then there's a previous one to that talked about, look, we may remove some regulations that were just put in place before President Trump took office. If you were watching from Jan 1 to Jan 19, like I was, the IRS, they were just putting out stuff. I mean, they always do that, but they were just put out a ton of stuff. I mean, it was just every other day was a regulation, final reg, whatever it was. But you have these 2 executive orders and this new one that's saying, look, for every 10 regulations you put out, for every 1 regulation you put out, you got to kill 10, which to me is a Herculean effort. I think that's almost like mission impossible. And so you and I were talking prior to the podcast, and we're saying, like, could we see a world where for the next 4 years, there's no IRS guidance whatsoever? Because if they can't put out regulations and they're getting hammered by Loper Bright for doing this informal guidance, right? Because that stuff's no longer flying mustard notices, rev procs, rev rulings, the memos that you said, those things aren't, those are maybe their position, but and suggestive guidance, but really not going to win the day there. Tell us about that. Tell us about how that works. Give us your opinion on could the DeFi regs go away? Does the 1099 DA form survive if it goes away? I'm curious.
And so, because we have these 2 interplays. We have this new executive order, which is just a remake. It just ups the ante, right? We're now killing, instead of 2, it's 10. On that. But the other thing is the Congressional Review Act, which allows everything, I think within 90 days of the new president taking office or the new Congress taking office, you can yank back any regulations that were done in 90 days, subject them to House review, to congressional review, and potentially remove them. That's what you saw in the tax note article, what they're talking about with the Ways and Means Committee. That was the push that was done. Now, and you can link to this if you want to, Mishkin, because I wrote an article in Forbes. Literally the day those regulations came out, a bunch of cryptocurrency trade groups filed a lawsuit in Texas, in the Northern District of Texas, challenging those regs. And they were using all the usual suspects of Loper Bright and APA challenges and everything along those lines. They filed it immediately that day. And I have a Forbes article that kind of summarizes what the arguments are and what they were making, and they were doing things.
Okay, we'll definitely link to that.
Yeah, there hasn't been a lot of activity on that case, because I think all of those trade organizations then moved to focusing on just yanking it back through the Congressional Review Act. And Ted Cruz got on. He's a senator in Texas, and so he got on board with being kind of the champion of that thing. And I think, and don't quote me exactly, but there were over 100 cryptocurrency organizations that signed a letter to Congress advocating for the pulling back of these regulations under the Congressional Review Act. which would make the lawsuit unnecessary.
Right.
They, so all the suspects who filed the lawsuit, I think they just switched their attention to Congress. And I think you're going to see more of that for regulations as well, because, you know, you can lean on your congressman to essentially say, hey, listen, here's our thoughts on which 10 you should kill. You know, the IRS just came out with this reg.
Oh, I see.
Here,
proactive on it. Interesting. Yeah.
Here's the 10 that we think you should kill. Because, I mean, there's a lot of lobbying efforts that go on in DC. I went to law school in DC at American University. That's where I went to law school. And so in DC, there's a huge lobbying effort. Every single law firm in DC has a lobbying arm, has a tax lobbying arm that does this kind of stuff for whoever their interest group is. And I think you're going to see that is there's an enormous opportunity for certain trade groups who know that the IRS has to kill something to put pressure on congressmen who will send or the Treasury Secretary like a full court press on, hey, we know you need to issue these regs. We know you need to kill 10. Here's our wish list of everything that we think needs to go. And the IRS may be able to do some with just clearing the brush on some old regs that probably needed to go anyway. But 10's a high mark to hit. And so I think you're going to see some playing with that as well.
If you kill 10 under this president, and then another president, let's just say the Democrats come back in and win, the 10 that were killed, do you think they can revive them at that point in time? Like, could they come back?
So the problem is under the APA, you'd probably have to go through the notice of comment process again. And it's a long and a lengthy process. And, you know, the IRS has tried to streamline that on several occasions, and it's never gone well. It's gotten kicked, right, for not going through the formal process. And with Loper Bright and the removal of Chevron and that kind of stuff, I think I don't, depending on how many get eliminated, I just don't know. Like in 4 years, I don't know how many regulations you can push through. I mean, there's some, as you know, and other people know who work in the tax, there are some areas of the code that we've been just using proposed regs for decades, right? because
the PFIC rules is my prime example. I've had people ask me about PFIC questions, and I'm like, well, there's a temporary reg that expired like 8 years ago. You could maybe follow that one if you really want. I mean, yeah, there's all sorts of. I agree with you on that. There's a lot.
Yeah. So right. Theoretically, they could just revive the exact old reg in its exact old form in temporary and proposed format, and then everybody could just rely on it while the crazy task of noticing, comment, and finalizing and everything happens. But again, with that, you still need staff to do it. And, we just fired 6,700 IRS employees. So there's less headcount there to do it. There's a complete freeze on hiring anybody new. You still have to have a body to do it. And right now, we're going through this massive sea change where you don't necessarily have the bodies to do that kind of stuff, because I think you're going to see at the IRS, they're going to have to triage now. And so things like regulations, they're not a required thing. They're helpful, right? But they're not a required thing. And so if you're down people, you're going to see people moved into enforcement functions, criminal functions, other things that just have to happen to keep the tax system honest. And a lot of the guidance, the manning of the phones, the taxpayer services type of things, people are just going to have to be reassigned from those, which means longer wait times for us and that as well when we're trying to get answers to this kind of stuff. And I think, like to kind of the beginning of this conversation, I think we could see a situation where there just aren't any regs because the people who would otherwise do them have to do other things that are more important because they're taking over jobs from people who've been who've been let go.
Yeah, let's talk about that for a second. So yesterday, so today's February 27th, just for the listeners. That's the day we're recording this. Yesterday, on the 26th, there was an executive order called Implementing the President's DOGE Cost Efficiency Initiative. And so, Josh, you mentioned earlier that 6,700 IRS employees were let go, and I believe most of those came from SBSE, which is when I was with the IRS. That's where I started. And they do a lot of work. They do a lot of work there for the IRS. SBSE they do a lot of heavy lifting. And then I think you also talked about the freeze, and there was, I think, 2,000 to 3,000 people that were set to start, right? A lot of them being law students, and my heart goes out to those folks, because I remember being a law student coming out trying to get that first job, and you get your offer letter and then it gets rescinded, right?
I mean, 21 years ago, I was holding an offer from the Department of Justice. I came in through their honors program, and right, like I was exactly that person who had their offer pulled, and right, I feel bad for them too. And the other thing is right, like it's an honors program. The DOJ only took 5 people. The tax division only took 5 people out of the. I mean, I think they said they had 1,000 applicants for that thing.
Wow.
And so most of those people they're really good attorneys who turn down other private firm jobs to work in government, because it's easier to work for government coming out of law school because you don't have to take a pay cut, right? You're already not making anything. And so, and that's the calculus I used. I had tons of other friends who went to other government agencies and other things like that, who had the exact same calculus. And so that's the other thing that I think is a little bit problematic. They're losing a lot of good attorneys, I'm sure, because
I mean, I think if you read between the lines of what you just said, you're talking about, normally they take the top guns, right? They're taking Maverick, they're taking Iceman, they're bringing them in. You guys are doing great. They're doing great work for the DOJ and the Treasury Department. But getting back to this executive order here, so now we've got the next big milestone is March 13th, and there's going to be another cut, quote unquote.
Yep.
And if you just do the math, right, I think they were at 103,000 employees. I think when I was there, it was 80, maybe 70,000, high 70s. So, the question I have is, at what point will the cuts have a significant impact where there's a red line there where it's tough for the IRS to really do anything at all other than just try to hold on for dear life and maintain. And then I think you were talking about before we got on the podcast that you're getting a lot more uptick in inquiries, not necessarily about like audit or examination or some of the stuff we've been used to for a while, voluntary compliance, but more like proactive planning. Talk to me a little bit more about how that space is developing. And then I know I'm throwing a lot at you here. Sub question though, which is I think the hockey stick industry for 2025 is tax insurance. And I want to do a whole podcast on tax insurance because I'm a big believer in it. I think given the fact that we're not going to get a lot of regulations, given the fact that the IRS is going to be somewhat crippled and we're going to be operating in a lot of gray space, more so than we ever have been before, I think for some of these taxpayers with these really big transactions, I think you need to think about tax insurance. I think it's that sixth man or seventh man or whatever they call it. What's in basketball? They have the crowd that gets into it.
Yep.
That's I think the shield that I think some taxpayers. I've routed already a couple people. I've said like, hey, go talk to Gray. Go see Josh. Go see Austin. Go talk to Gray Reed. Get a legal opinion. Get tax insurance. But sorry to relay so many different questions to you. But
no. It makes perfect sense. And so I'll kind of back up a little bit and say why this is important right now, because we're seeing an uptick in the clients that are coming to us. For the longest time, it was clients who were coming to us essentially to fix problems, or right, they'd been picked up for audit and things that were not necessarily clear back right in 2015 or 2016 when cryptocurrency wasn't even cool yet. They had those issues and they needed to have them fixed. Or we had compliance people about, hey, how do I comply? This new reg has come out. This new guidance has come out. That kind of stuff. And it's been mostly disclosure and compliance. But now people with what happened first was the Bitcoin price went up, and whenever the Bitcoin price goes up, all the other cryptocurrencies tend to follow along with that. So that's the first thing that happened. The second thing that happened was this ETF boom, right? We had the Bitcoin ETF get approved, and just tons of money was being dumped into this ETF. Then some ETH to ETFs got put in. So more money is being dumped into that. And then with the regulation easing up in other countries, and now the US looks like it's going to follow, right? Globally, we saw a huge wave of tokenization projects occurring using stablecoins and other cryptocurrencies to essentially monetize and digitize revenue streams in real estate, oil and gas, all these industries. I'm going with that. And we're now starting to see, everyone's seen kind of the first people who were willing to dip their toe in, make a decent sum of money using it. And so they're starting to see the use cases for cryptocurrency going forward. And so now we have people with legitimate tax questions. Okay, if I digitize this financial product, it's always been like, I mean, the tax treatment of financial instruments is already quite complicated.
Yes.
I remember handling them at DOJ. I handle them on the outside. And so, okay, I have this financial instrument. It doesn't necessarily look exactly like the derivative I'm used to or the debt instrument I'm used to. It's different, right? And it's got different attributes to it. Can I assume that it's taxed the same or not? Right. And those are the types of issues that we're starting to see now. And unfortunately, it's coming in an environment where I don't know how much you'd be able to get done. I think the only option that a lot of those people have now is a tax opinion, and just take the position on your return and buy insurance to back it up just in case. Right. And the other one would be a PLR, but again, with a reduced force, right, that's discretionary. They may not take it, or they may limit the types of PLRs they issue, in which case you're left with that. So the tax insurance, I definitely think, is going to become it's going to become better. And that tax insurance, at least from my perspective, it's always best before there's litigation. It gets way more expensive if you're already in a dispute, either an audit or that. So on the front end is way better for this. Hey, I have this novel idea. I think it fits within the normal, tax treatment for things like this, but I don't know. And so you pay for a tax opinion, which the insurance carrier requires. And as long as you can get to a certain level of confidence, they're able to insure it for what seems like a pretty reasonable thing. And should you end up being wrong, right, you're covered. And what it does is it allows a taxpayer to still engage in a project without having this kind of minefield sitting out there that the whole thing could be undone and their bottom line is all screwed up. You can kind of mitigate those costs. And just build it in to the financial.
So, just to be clear from what I'm hearing, to get tax insurance, you need to get a legal opinion with a certain level of confidence. Do we still call those reliance opinions, or what? Is there a certain term that we? So if I'm calling you and saying I need that, what verbiage am I using to describe the type of opinion that I'm?
Yeah, it is a formal tax opinion. It meets the requirements of Circular 230, which itself was just amended to make it a little bit more strict on what attorneys can do. So we're all dealing with that anyway. But yeah, in the times I've used it, the insurance carrier usually likes to see a more likely than not opinion, because that would be a 51% or higher likelihood and confidence in that position, which can be hard with a lack of guidance, right? Because, I mean, substantial authority is what sits right under more likely than not. And if you don't even have a lot of authority to rely on, you may not. So I think there's going to be a lot of tax advisors like myself are going to be drawing a lot of parallels between existing law because there isn't guidance out there, unless there's new legislation, in which case we could point to the legislation at least, but there probably won't be a whole lot of guidance on that afterwards as well. It's going to be very interesting because it's an incredibly lucrative time right now for blockchain and digital assets, but it's also still pretty risky. And we represent financial institutions, and we represent pretty big, companies that they have like $1 billion worth of revenue for their normal business, want to incorporate some digital asset aspects to it, but they have to be very, very careful, and they don't want to, have some really risky thing that they have to deal with otherwise.
And is it your kind of observation that when you're writing these opinions and you're doing the tax insurance that you're also so you're covering federal? Are you covering state? And then if you had someone with a cross border and with a foreign country, are you also covering a foreign jurisdiction? Is that all? Are you getting all of that in a bag of chips, or is it limited?
You absolutely can, right? The only question is a matter of cost, right?
Right.
Because absolutely, right? Like, I mean, the analysis is just bigger. So if you're doing federal, you can do federal, right? That's the analysis for that. If you add in a state taxing agency, like I always think of the big ones, which is like California and New York, right? Those are the big, giant revenue. They're the ones that are big enough to kind of operate similar to the IRS. In that way. So if you have the California FTB, then yes, right, you can do the analysis of their own guidance and their own opinions that they put out, other test cases and things, and you can get to a tax opinion there. And then in international, you get an international expert. You probably would need a local person in addition to a U.S. person to interpret any treaty provisions between the two and stuff with that. So it involves more lawyers, but it absolutely can be done. But the more lawyers you add, the more the cost goes up. And so I do think that, I mean, the good news is there's a lot of these transactions and they do involve larger dollars, right? If the Blackstones and billion-dollar revenue companies are looking at doing something, there's usually enough money there that it's worthwhile, right? Okay. To go through the process there. But the bad thing is that if you're a small startup or an entrepreneurial type of thing, and you just don't have a lot of capital, it might be harder. But we are seeing a bunch more venture capital also being dumped into the cryptocurrency space. Lots of people have decided that investing in tokenization or something else along those lines is valuable for them, and we're seeing more startups that have, funding streams that are pretty decent size that can match that. But we are also seeing some people who just, when they look at kind of all the cost involved because of the uncertainty, they're just priced out.
Yes.
And so it's kind of unfortunate that there is kind of a line where it no longer makes sense just because the costs are pretty high right now, only because of the uncertainty.
I see. Okay. I mean, I look at it, for the next couple of years as a hockey stick growth area too. I mean, for a while there, it kind of went down, up, down. And I think the next couple of years, it's going to be kind of a big, big deal. Let's go back to some of the stats I led off with about the criminal investigation prosecution. Yeah. What's your feeling about current kind of enforcement? I know that, if we think about the big cases here in 2020, into 2024, 2025, you've got the Bitcoin Jesus case. You've got, there's a Maryland lawyer that kind of did some shenanigans that they're currently investigating. There's the Tate case out of the UK where you've got, a bunch of, I think the UK seized, 2 million pounds for crypto, from a cryptocurrency holding business. You've got insider trading cases with the SEC. Was it the Wahi case? So walk me through there. Like, are we going to see more of these, less of these? Do you think, or Same, like what's going on in the area of litigation right now?
Yeah. So criminal is interesting. I think in the civil realm, we're going to see less crypto cases being brought. And I think that's just because the enforcement has been very, very aggressive. Mm-hmm. And with Gensler in particular, right? He just decided that everybody was a security, and so everyone needed to be investigated, right?
Right. You get an insider trading case, you get one, you get one.
Yeah. And so everybody was being investigated under the Gensler regime, and a lot of people really, really were happy to see him go. And in his place, Trump appointed somebody who has been vocally pro crypto. So I think civilly you're going to do this, but the problem is the way politics is, nobody wants to be seen as easy on criminals. Okay. So right, like the problem is that I think they're still going to have to bring enough cases and enough high profile cases to show that, hey, listen, we're limiting regulation. We're making it a more friendly environment for the people who are doing the right thing. But bad actors, they're still being punished, right? And so I'm going to address the two of them differently. I'll start with criminal because yes, we've definitely, so we have cryptocurrency criminal cases kind of come in two spheres. There's the fraud cases. And that can be any amount of fraud that's going on. And then there's the non-fraud cases. And so I think we're still going to see a trickle of a lot of fraud cases being brought, and a lot of insider trading and some of these pump and dump schemes and Ponzi schemes and all the usual suspects on the SEC side. I think we're going to do this. Now, from a tax perspective, I think that ends up interesting because the pure tax criminal cases, there aren't very many of them. Right? Bitcoin Jesus is probably the most high profile one. That is like pure false statements on a tax return, and a tax loss is the primary driver for the criminal case, and it'll be the primary driver in deciding what the criminal sentence will be. The other one you didn't mention, and I can only do the public one, is the one that I was defense counsel for, and that's the Algren case, which is finally pled out for that. He pled and was sentenced to 24 months for the $1 million tax loss that was alleged on that one. And that, again, was 3 claims of false statements on a tax return regarding his basis in the Bitcoin that he sold in doing that. Then you have Bitcoin Jesus, who is primarily an exit tax, is what we're talking about there. He expatriated in 2014, hadn't been in the US for a long time, but was arrested in Spain and is waiting extradition to the United States. Again, with him, it's statements that that's an interesting case as well. So the Algren case, I think, was interesting for how it was prosecuted. Government had a bunch of chain analysis experts that were involved in there. But what you saw is cryptocurrency is still somewhat anonymous and hard to, it's easy to track on the public blockchain. It's hard to connect that to an actual person. That's the difficult thing. And not impossible though. And the easiest way is on-ramps and off-ramps. And one of the big things in the indictment for the Algren case, the one that I covered, was the fact that he had purchased a $4 million home, right, in Park City. The purchase of that is the off-ramp. And if you can connect the off-ramping of Bitcoin from the network to a person, you can work backwards now. And now you have a connection to a wallet or a transaction stream or a cluster of, sales or something, and that can connect to the person. So that's what I find interesting about the Algren case is that's, I think, what the government is going to be focusing on. If all of your assets always stay on chain and they never come off and you never use them for anything, you're probably pretty safe. Otherwise, it's not a very good place to hide money because it's all public and it's easy to go. The government has tons of analytics and vendors that look at everything. So Bitcoin Jesus is interesting for a different reason to me from a tax perspective. When you read that indictment, almost all the information that is being used against him and charged against him is from his tax advisors. Wow. It's questionable whether or not they were from his tax attorneys, but most of them seem to be from his CPAs and his accountants. Back in 2014, when he was planning on expatriating, he actually got a lot of advice from CPAs and attorneys on how to do this. And in 2014, we had one notice from the IRS on how it was doing. Everything else was informal. And that one notice is completely wrong now, right? Because it said that, cryptocurrency doesn't get to be counted as a currency because it's not accepted as legal tender anywhere. Well, that's not true. El Salvador does. There's a province in Africa that does. So it is accepted as legal tender in a foreign country now. So it's possible that that whole thing is outdated and it could be treated as a currency. So regardless, but he was taking certain positions based on limited guidance and he was asking his accountants and his attorneys about it. And the problem is that accountants have their own privilege under the code 7525 that's supposed to mimic the attorney-client privilege, but it has a gigantic hole in it in that it doesn't apply to anything criminal, which means that it was probably his accountants that were forced to turn things over because of no protection for privacy under that. And that indictment, when you read it, you can see that they essentially got a ton of information from his tax advisors. I think that's terrible only because I think it's going to discourage people from being very forthcoming with their accountants and potentially roll up and even, be less forthcoming with their attorneys. But that's what I think is interesting about him is most of the evidence that's being used against him to support that indictment, I think came from his accountants in that case. And then the last one, and then I've spoken for a long time, is
keep going.
Which you mentioned was the Goldstein case. Tom Goldstein, he's the founder of the SCOTUS blog, which has covered the Supreme Court for decades. It's the most popular blog post for Supreme Court activity. He himself had argued 45 cases before the Supreme Court. And just before anybody figures out the backtrack as well, I mean, he went to American University, so he's an alumni. I've heard him speak at his law school and other things like that. He's an alumni of our school, which that is what it is. But what was interesting, everything else is way more exciting than the tax charges in that case. There's a bunch of explanations of gambling and infidelity against his wife and stuff like that. None of which, right? Like everybody is innocent until proven guilty, but there's a ton of salacious details in there. And then there's these couple of charges, and they are literally assisting with the preparation of a false tax return. And they appear to be based entirely on his not checking the box that he had cryptocurrency.
Oh, on page one of the 10.
Page one, right?
Ah, interesting.
The fact that he didn't check that box seems to be the primary driver of these charges for the assistance in preparing a false tax return, right? Because he didn't tell his return preparer that he did have cryptocurrency transactions, that box was not checked. And that now is a 3-year maximum charge for literally just not checking that box. And saw that box first on a schedule, moved to the front of the return, so that it was more and I think that was a result to all the litigation we had over FBARs, right? I did a bunch of that, and there were a lot of arguments that, hey, listen, the government was trying to argue that because you didn't check the box on the schedule, that was willful. And people would shoot back and say, sometimes that schedule doesn't even come up, right?
If you don't have anything on part 1 or part 2 of B, it doesn't print.
Yeah, exactly. And so I think the government, because there was so much pushback and they were not able to prove willfulness and things on that, I think that's why, learning their lesson from the FBAR litigation, they put it on the front of the page. And I think this is another attempt to kind of draw the line on that kind of thing. Hey, listen, you don't check that box, there's a criminal charge that we can stick you with. And look, we have done it. We will do it. Right. Ultimately, I don't know if that gets like removed as part of plea negotiations, but I think it's in there for that purpose, for deterrence against people not checking that box when they have cryptocurrency transactions. So those are kind of the 3 biggest ones that are still kicking around. Bitcoin Jesus, they've all briefed whether or not he can be extradited, and whether or not the indictment's going to be dismissed, constitutionality of the exit tax and things like that. That's all been briefed, and we're just waiting for a decision. In that case, Goldstein is just starting. So that one is there, and Algren is over. But those, I think, are the 3 main tax criminal cases involving crypto right now.
And I'll make sure we link up to all 3 of those in the show notes. Let me just kind of summarize.
I have a Forbes article on those too.
And the Forbes article, which you're going to send to me, for absolutely. So let me just summarize a couple of thoughts I had on what you just said. So let's start with the last thing you said, which is something that I beat the drum on every time I do a compliance presentation. It's really funny because when I get invited to speak at conferences, I feel like it's a lot of attorneys that are speaking, and they're speaking very high level. And then I come in and I do my dog and pony show, and I'm like, but have you seen this form? And I beat the drum, and I even will snip out sections of our firm's tax organizer related to digital assets. And I try to tell the CPAs of the world and the folks that are listening, I'm like, you got to ask the questions, just like the FBAR. For years, tax practitioners never had any questions about foreign bank accounts. And that does a disservice. Clearly, you can see they're picking it up. They're using it as an argument. Even if it doesn't hold water or translate through at the very end, it's still something they can hang their hat on. And so I would tell a lot of CPAs or a lot of tax firms that are listening, make sure you have something in your questionnaire, a section about digital assets, cryptocurrency, and make sure you train your staff on how to answer that question at the beginning of the tax return. I have a blog post where I talk about it. It's kind of like an SAT question. If you look really close at it, it's like, you kind of have to almost like chop up the phrases and like understand what it's really asking you, because it's a 2-part question now. The second thing that I heard there about Bitcoin Jesus, which is another drum that I'm beating right now, which is we have a lot. I see a lot of cases where people come in and they want to exit, especially since anytime a new president takes office, the uptick and people wanting to exit. It doesn't matter if it's Democrat or Republican, but you have these gray areas now because 877 Cap A has no regs. The notice 2009-85 is, I mean, gosh, how old is that thing? I mean, that's from aptly named 2009. And the Resti case, the court in that case basically said this thing's a no-go. So I think the moral of the Bitcoin Jesus story is be really careful about your exit tax advice. And this goes back to my comment. You may need, on some of these issues related to exit tax, you may need to go get an opinion and go get some tax insurance. Because if it turns out if you filed as a non-covered expat and then they come in and say, well, no, you're covered, and you lose, then there's real dollars in post-exit tax implications that can occur. It forever changes your life. It will always stick to you. And I'm super interested to hear if you have any thoughts on whether the final 2801 regs will actually stick around, or they'll pull those too in congressional review, or maybe the 10-1, maybe those get knocked out. Or maybe there's something if they actually repeal the death tax, right? And they, then you lose maybe the covered bequest tax that goes with that in the 2801. But there's a lot going on there. And then I would just tell a lot of people, just like with the international tax compliance, that's why people come to the Wolf Group, right? You come to us because you have a foreign trust or a controlled foreign corporation or an exit tax issue. Someone comes to me with just a K-1 and a W-2 and a 1099. It's like bringing a howitzer to a knife fight. But when it comes to complex digital asset reporting, there are very specialized firms, tax firms. I know of several of them that they're really good. And I'm trying to get them on the podcast, where sometimes we'll look at it and be like, hey, that's outside of our sandbox. So you got to go talk to. We're going to refer you out to it's kind of like referring a family practitioner and saying, I'm going to refer you to this heart specialist or this foot specialist, right? You got to know your sandbox and play in that sandbox appropriately, and don't come in with a bunch of DeFi transactions and expect to walk into H&R Block. No offense to H&R Block or any of those DIY places, but don't go in there thinking you're going to get it done right. So, any thoughts on any of that?
Yeah, actually, I have one as well. So it's interesting that you say that, because the international component is huge, because we have a lot more expats in the digital asset space, and we have we have some people who are just deciding to go out, and the reason is the regulations and the ability to operate a cryptocurrency or digital asset business in foreign countries is way easier.
Yep.
The United States, for the first time ever, I think, is behind the ball on technology. All these other countries have been way more accepting and open for digital asset and blockchain companies. And so everybody is moving. Like India, for example, had decided, which I personally thought that this has always been the case. I've been saying since 2018 that digital assets needed its own lane, stop trying to put it into all the other categories we already have. Just give it its own lane, treat it as its own asset, and regulate it as its own asset. India did exactly that. They have separate laws and regulations for, cryptocurrencies. They have them for stablecoins. They have them for NFTs, right? They decided to break them up into their own different asset classes and treat them differently and regulate them differently. And other foreign countries, they just don't have the same kind of restrictions and other things like that. So the Americans, who do have like a lot of really intelligent, great degrees, they're super coders, they're ready, they know this technology and everything very, very well. They just decided to relocate to a foreign country. And so those issues come up like crazy. And the United States, in those regulations that they issued for brokers, they first said, we're not following OECD.
Oh, yeah.
And then they came back and said, we changed our mind. We are going to follow OECD. We need to amend these to incorporate OECD things. That's never happened. Mm-hmm. And now, technically, I don't know that it can without tripping all these executive orders. So what we now have is what we have in the foreign account world too. Everybody else follows OECD. The United States has FATCA.
Right.
And right now we have the same thing. The rest of the world for digital assets is following OECD, and the United States has nothing, right? Like we don't have anything in there except a promise to follow OECD, which we don't, which makes it difficult. Anybody who works in data privacy or cybersecurity knows that they're having to go within the United States. You have different privacy rules from California to New York to everybody has their own privacy rules, in addition to getting into the EU and then everybody else. And we're kind of getting to that point where it's incredibly complicated. You need a specialist now because somebody has to be keeping track with like a dozen jurisdictions that you may have reporting obligations or other obligations for, because that's what we have. And I mean, we already have huge problems with loopholes in FATCA as it is. It's when I was at the DOJ, I was filing John Doe summonses on behalf of several foreign countries because of that loopholes in FATCA. Lots of foreign nationals were using the United States as a tax haven,
Right.
because of the reporting thing. And so those foreign countries were having to try and get information out of the United States in order to support their own tax evasion programs there.
Very difficult.
And I think digital assets, we're gonna see something similar with that.
Okay. Well, great. Look, I think we're closing out here. This has been a fantastic discussion, and certainly, you talk about you being a frequent flyer. I definitely want you to come back. I think this is an ever evolving space, and it's just going to keep moving forward. And so we definitely want you to come back and give us another update. But any concluding thoughts for the audience out there? Any big takeaways that you want to highlight, or things that you want to maybe foreshadow, like beware, like Caesar, beware the Ides of March, anything like that?
Well, I think, one thing I would like to add on is, right, there's been a lot of kind of, oh no, look at all these terrible things that can happen and everything there. I do want to kind of mention that it's a really exciting time for digital assets and crypto. It really is, because people are I am always super impressed by the clients that come to me, like the intelligence and novelty of the things that they're doing with this new technology. It's incredible. And I think there's a lot of things to be excited about in this space. My predictions is I think we're going to see in 2025 a lot of our traditional, especially financial products, because I think it's the easiest thing, we're going to see those switch over to tokenized versions.
Oh, okay.
I think the ETFs were the start of that, but there's a lot of debt instruments and derivative instruments and other things that I've seen and litigated and dealt with both at the DOJ and private industry that are easy to transfer to the blockchain in a tokenized version, and it'll be so much faster than everything else. I think the main stumbling block that is stopping that right now is still some mystery and uncertainty regarding stablecoins. I think that a stablecoin bill is probably the easiest one for Congress to pass. There's already versions of that out there that they've been kicking around with. And so I think that this administration, because they are pro-crypto and they want to show the crypto community that they've done something, the low-hanging fruit, I think, is a stablecoin bill. And once we get that stablecoin bill, I think you'll see the floodgates open, and all of the debt instruments and derivative instruments and all that other kind of stuff, we'll start to see tokenized versions of those kind of just flow from that. Maybe I'll come back on if we get a stablecoin bill.
I would love to. Just real quick, I know I said that this is it, but just 2 seconds for me real quick.
Sure.
Stablecoin bill coming into a TCJA extension, or just by itself?
By itself. I think it's going to be its own standalone regulation. They've been trying to pass that for a long time, and they just haven't been able to do it. They just haven't been able to kind of do it. But it seems like it's an easier sell for a stablecoin bill, because the only thing that you have to make sure in the legislation is that you have clear lines for stablecoins so that you can prevent the fraud that happened with Luna, right? Like if you have an algorithmic reserve, then that's problematic, because if pieces of the cryptocurrency ecosystem fall, like your algorithm blows up. Now, I'm not a PhD in math.
You sound like one though.
You're right. Like, I follow numbers. I'm a tax guy, so I'm very into numbers and everything like that. And I remember when the algorithmic stablecoin started coming out, in my head, I said, I don't see any way that you can create an algorithm that would actually one for one. I was like, I just don't, it doesn't seem mathematically possible to me. And then Luna crashed, and I was somewhat vindicated by the thing. It just didn't seem possible. I think what USDC is doing, where they essentially are just burning one for one as stuff gets transferred, that's the way to do it. They have a gigantic reserve. It's all in dollars or treasury bills or some other thing that truly can mimic a dollar for dollar change for USDC. What that allows everyone to do is it gives them a cryptocurrency with all the stability of the dollar for which they can do transactions, tokenized versions of the financial instruments that they're already familiar with. And so I think that's what they need in order to be, but someone has to draw the lines on what will count as a stable coin, what you can and can't do in order to, so that they feel like there's
the cover. Yeah, the cover for investing. All right. Well, that certainly, if there's the standalone bill that gets passed, you're coming back on. I'm going to hold you to it.
Sounds good.
Thank you so much for coming on today. It's been fantastic, and we'll see everybody next time.
All right. Very good.
You've been tuning in to the Essential Tax Podcast with your host, Mishkin Santa. You can find this show on all the major platforms, including YouTube, LinkedIn, Apple Podcast, Spotify, and on our website, thewolfgroup.com. Thank you for your positive reviews, comments, questions, and for sharing this show with others.